In 1928, a clerk in a colonial surveying office typed a comma in the wrong place. Not a bribe, not a conspiracy, not an act of war. A comma. And that single keystroke error, buried inside a 43-page mineral extraction agreement, would go on to kill thousands of people, redraw two national borders, keep two sovereign nations at military standoff for 4 consecutive decades, and funnel billions of dollars in oil royalties to the wrong government for 40 years, all because nobody proofread the document before it was signed. That is not a metaphor. That is what happened. Let us go back to 1921. The world had just survived the First World War, and the great powers were repositioning themselves for the next great contest, which everyone understood was going to be fought not with bullets first, but with oil. The British Empire, the French, and a handful of American corporations were racing across the Middle East, South America, and Central Asia to plant flags on anything that might be sitting on top of a petroleum deposit. Speed was everything. Due diligence was optional. In this environment, the standard operating procedure for securing a mining or extraction concession was to reference geographic coordinates from existing colonial survey maps. Those maps were frequently decades old. They had been drawn by explorers who were not surveyors, using instruments that were not precise in terrain that was actively hostile to precision. But they were the official record. They were what the contracts referenced. And for a long time, as long as the oil was flowing and nobody was looking too closely, nobody cared. The Chaco region, the vast contested interior between Bolivia and Paraguay, sat on what geologists in the early 1920s had begun identifying as a potentially enormous petroleum basin. Standard Oil of New Jersey, operating through Bolivian concessions, believed the richest deposits were accessible from the Bolivian side. Royal Dutch Shell, working through Paraguayan arrangements, believed exactly the same thing about the Paraguayan side. Both could not be correct, but both were willing to act as if they were because the boundary between the two nations in that region had never been formally settled, and the colonial survey documents that were supposed to define it were, to put charitably, a mess. Now here is where the comma enters the story. In 1928, negotiators from Bolivia and Paraguay, under pressure from their respective corporate backers and with the League of Nations watching, sat down to draft a preliminary resource-sharing protocol. The document was supposed to define which territory fell within which nation's sovereign extraction rights. It referenced a specific set of coordinates from an 1894 Argentinian survey map. The relevant line in the document read in the original Spanish as a coordinate range that, in precise translation, meant the boundary ran from one defined landmark to a second defined landmark, and everything west of that line belonged to Bolivia, everything east to Paraguay. The clerk who typed the final version placed the decimal point and the comma in the wrong position on one of the coordinate references. It shifted the described boundary line by approximately 70 kilometers. 70 kilometers in the Chaco is not a rounding error. It is the difference between sitting on top of an oil field and not sitting on top of an oil field. When the document was signed, ratified, and stamped with official seals, neither government's legal team caught the discrepancy because neither team had cross-referenced the typed coordinates against the original 1894 map. They trusted the clerk. By the early 1930s, Bolivian and Paraguayan survey teams operating in the Chaco began reaching contradictory conclusions about who had the right to be where. Each side had a signed, ratified, legally binding document that appeared to support its position. Each side also had a corporate backer with hundreds of millions of dollars in potential royalty income at stake. In June 1932, Bolivian forces attacked a Paraguayan garrison at a fortified post called Padian Tuta. Paraguay declared war 3 weeks later. The Chaco War had begun. What followed was 3 years of some of the most brutal warfare in South American history. 70,000 soldiers died. Many of them did not die in combat. They died of thirst in a desert that both nations were fighting over for oil that, in a bitter final twist, was found to exist in far smaller quantities than either Standard Oil or Shell had projected. The war ended in 1935 with a ceasefire and a temporary territorial settlement, but the underlying boundary dispute, rooted in that corrupted 1928 document, was not formally resolved until 2009, 81 years after a clerk misplaced a comma. And the oil royalties. The disputed zone produced modest but consistent petroleum revenue from the 1940s onward. For 40 decades, while the legal dispute remained formally unresolved, those revenues were held in a kind of suspended international escrow, contested, partially paid to one side, partially to another, subject to ongoing renegotiation, consistently entangled in litigation. The total value of royalties affected by the unresolved boundary during those 40 years has been estimated by economic historians at between $3 and $6 billion in modern terms. $3 to $6 billion, tied up, fought over, partially lost to legal fees and political corruption on both sides, because a comma was in the wrong place. Here is what this teaches you. Lesson 1. Language in a legal document is not administrative formality. It is the architecture of power. Every comma, every decimal, every coordinate reference, every unit of measurement in a contract is a load-bearing wall. Remove one or shift one, and the entire structure can collapse. Or worse, it can stand, but describe a completely different building than anyone intended. The Chaco boundary document looked legitimate. It was signed by diplomats. It had official seals. And it was functionally a different agreement than the one both parties believed they had signed. In business, in employment contracts, in partnership agreements, in intellectual property filings, the same mechanism is at work every day. A clause that is slightly ambiguous does not stay ambiguous. Whoever has more power or more lawyers will resolve that ambiguity in their favor. Lesson 2. Ambiguity is not neutral. It is a weapon that activates the moment money is at stake. Before the oil surveyors arrived in the Chaco, the boundary error sat in the document for 7 years, and nobody mobilized an army. The instant the potential value of the underlying resource became clear, every ambiguity in every document suddenly mattered enormously. This is not unique to governments. This is human behavior applied to contracts. When business is good and money is flowing, partners tolerate vague agreements. When the money gets tight or the stakes get large, every vague clause becomes a battlefield. The document that seemed fine during the handshake deal will be examined line by line when the relationship sours. Lesson 3. The people who rush the paperwork are never the ones who pay for the errors. The colonial administrators who generated the 1894 survey maps were long dead by 1932. The clerk who mistyped the 1928 coordinate was not standing in the Chaco in 45-degree heat. The corporate lawyers who pressured negotiators to sign quickly and get the deal done before the other side's backers changed their position were not among the 70,000 who died. The cost of a document error is always paid downstream by the people who inherit the ambiguity without having created it. Lesson 4. Small errors in high-stakes documents have outcomes that are violently disproportionate to their size. A comma is not a big thing. A decimal point is not a big thing. A missing word, a wrong unit, a transposed digit. None of these feel significant in the moment, but their significance is not determined by their size. It is determined by the value of what they govern. A typo in a personal email costs you nothing. A typo in a patent filing can cost you the patent. A typo in a contract governing resource rights to a disputed territory can cost you 70,000 lives and 80 years of unresolved litigation. Now, here is how this applies to your life today. You sign documents, probably more than you realize. Employment agreements, freelance contracts, partnership terms, software licenses, intellectual property assignments, non-disclosure agreements, lease agreements. Every one of those documents contains language that will be interpreted in a dispute by whoever has more to gain from a particular interpretation. Your job is not to trust that the other party drafted the agreement fairly. Your job is to read every line as if the relationship has already gone wrong, and you are standing in front of a judge explaining what that sentence means. Specifically, read every scope clause in an employment contract. The language describing what you are hired to do and what intellectual property you create on company time is frequently written so broadly that anything you build, code, design, or invent while employed, even in your own time, is assigned to the company by default. Many professionals have discovered this only after leaving a job to start a company and finding that their former employer has a legitimate legal claim on the product they built on evenings and weekends. The comma that matters for you might be in the phrase that defines what constitutes company time. Read every exclusivity clause in a partnership or distribution agreement. Read every jurisdiction clause in an international vendor contract. Read every arbitration clause before you sign it, because agreeing to arbitration in advance frequently means giving up your right to a jury trial and significantly limiting your damages options before a dispute has even occurred. None of this requires a law degree. It requires the habit of slowing down before you sign anything significant and asking one question. If this relationship goes wrong, what does this sentence give the other party the right to do? The 70,000 soldiers who died in the Chaco did not know they were dying over a misplaced comma. That is exactly the point. The consequences of a document error are not announced in advance. They accumulate quietly until the stakes are high enough that the ambiguity becomes impossible to ignore. By that point, the document has already been signed, the error is already in the record, and the only question remaining is who is going to pay for it. In 1928, a clerk placed a comma in the wrong position. Nobody checked. Diplomats signed, corporations moved in, and 40 years later, two nations were still arguing about where one country ended and the other began. The error was not the war, but the error made the war possible. Because in a world where billions of dollars and sovereign territory are at stake, an ambiguous sentence is not a minor inconvenience, it is an invitation, and someone always accepts.